All right, we are back in Senate Judiciary to take another walkthrough through the new combined bill of H98, which has attached to it S95. We'll go over some of the changes that we made, and there's no further changes. We can probably take it up for a vote. And we have Ledge Council with us, so please take it.
Yes, thank you. To the chair, this is Eric Fitzpatrick with the Office of Legislative Counsel. As the chair mentioned, here to walk the committee through the proposed strike-all amendment that includes both H98 and S95. So what you're looking at now is a document that merges these two bills. Remember that the sort of connective through line between them is they both involve expedited processes for children in the probate division. Different topic in each one, but they both are involving that same kind of procedure. So the first piece of the bill is actually H98. So that's on starts on page 197, and that doesn't have any changes in it between what you see in front of you and what was in the language that you reviewed when Michelle covered this section. So she's the one who walked you through it, and there was many discussion on that. And you'll see there's no yellow highlights in that section because the committee seemed to be okay with the language as it was. And this is the bill that creates an expedited process for parents who have conceived a child through assisted reproduction and they're already parents under Vermont law. So it's this expedited process for adoption when someone's already a parent and they've used assisted reproduction to conceive. So that language is exactly identical to what passed the House in H98. Starts on page 1 and it goes up to page 5. So starting, just so you know where everything is here. So starting on page 5, line 15, that's where S95 begins. You see section 2 of the bill? So that would have been the first section in S95. S95 being the Senate bill enacted relating to standby guardianship for children whose parents have been subject to adverse immigration action. So this is a different procedure in the probate division. Similar idea though, an expedited process in this case to provide guardianships quickly for children whose parents have been subject to adverse immigration actions and prevent the child from otherwise ending up in custody for GCF. So there's an expedited guardianship process that can be moved along very quickly if the parents are subject to one of these adverse immigration actions, which the bill defines. So, as I said, that begins on page 5 with the definition section of the adverse immigration action portion of the bill. And you'll see the first change then, so the definition remains the same, custodial parent definition over on page 7, that's line 6 to 11, is struck. So you may recall that was a request that Legal Aid made and the other interested parties agreed to, and everyone seemed to be in consensus on that there really isn't a need for this because undocumented parents rarely have custody orders. So it's not practical or useful to define them in the legislation. So everyone agreed that it was unnecessary language and impractical to try to define that since it rarely happens anyway. I think the court was on board with that as well. So there was consensus to just take that definition out. So that is struck from the definition section on page 7. Now, the next couple of changes are also in the definition section over on page 8. This is the definition of adverse immigration action. So in order for the guardianship process to be triggered here, for the standby guardianship to come into play, there has to be, it's predicated on the existence of an adverse immigration action. So it's important how adverse immigration action is defined. And you see that there's a number of different ways. It's definition number 9 on page 8, 1, 2, A through E, I think it's 5. So there's 6 different definitions of it currently in the language, and there's a couple of proposed changes to those definitions. So the first one, and perhaps the one that would leap most to mind as to what an adverse immigration action would be, is the arrest or apprehension by a law enforcement officer for an alleged violation of federal immigration law. So if someone is arrested, when a parent is arrested for an alleged immigration violation, that counts as an adverse immigration action that would trigger the ability of the child's guardian to go into court with the guardianship agreement and say, if the parent were subjected to this, they've been taken into custody under federal immigration law. We don't want the children to be put into state custody. So we have this guardianship agreement. Probate court can approve it right away. That way the child has guardians to go with, rather than having to be go through with a DCF custody proceeding. So
actually, I'll disregard. Keep going. I'll ask my question.
okay.
All right, get the boss.
Yeah, sure. So the proposed change there, you see, is the idea, and then the committee discussed the fact that, well, it's the federal law enforcement officers who take people into custody for alleged violations of federal immigration law, because the state law enforcement don't actually have the authority to do that. So that's why the language change is proposed that you see there on line 9. So it's the arrest or apprehension by a federal law enforcement officer for violating federal immigration law. It takes the local and state law enforcement officers out of that equation.
My question, I know I asked this, I think a couple of weeks ago, I just can't remember the answer. Going to the bottom where it's the denial of admission or entry into the US by DHS or other local or state officers acting on behalf. I think I asked the question, if a family is trying to enter the US and they are denied, how would the child get a standby guardianship, or would they get a standby guardianship if DHS is saying your family is denied entry? Or would federal law just prompt that and they would be denied entry?
I think the idea of the structure is that the standby guardianship paperwork is already in place. It's happened before the adverse immigration action happened. So I think the advocates who work in this area have already had contact with potential clients. They are already aware of the many folks who would make use of these agreements. And so they draw the agreement beforehand. And within that agreement is the person who has volunteered to be the standby guardian. And that person can go to court and get the approval of the probate division for the guardianship. Because essentially it's documentation that's already been established. It's already been signed by, I remember, it requires a signature by the custodial parents. They've already been signed and agreed to. Again, predicated upon the existence of this adverse immigration action. So it only would come into play. But I think, as you mentioned, Senator Sheen, it's that was one of them. Which one were you looking at? Was it D or E?
I think it was E. Looks like we.
Oh, right.
Actually, no, I think I had F.
Yeah. Right. They're not entry into the U.S. by Home Security or someone else acting on their behalf. Right. So what would happen then is that the guardianship documents would have been already drawn up. That would have been agreed to by the parents. Whoever the guardian is who volunteered to be the guardian has been already identified. So this happens as you described at the border. The guardian would have the ability to go into court with the pre-approved, pre-signed documentation, and they would be able to establish the standby guardianship in that way.
Thank you.
Yeah. So one other change you'll see in the second definition of adverse immigration action, it's subdivision B, which is changed on line 13 and 14. Again, this is just to clarify, I think there's something the committee talked about and noticed that as written, B appeared to not be connected to the violation of immigration law.
Which page?
This is page 8. Yeah. So without the proposed highlighted language, the way it read was that any arrest, detention, or custody by Homeland Security or by local law enforcement acting on their behalf would count as an adverse immigration action, even though there wasn't necessarily a connection to immigration. So that's why the proposed language is added. And I read that by Vermont Legal Aid, and they agreed to that as well. So again, I think it's making sure that this is an immigration-related precondition to the guardianship kicking in.
I don't think we have the highlight.
Yeah, I'm not seeing the highlighting. I am seeing the addition. on line 13 and the 14,
Oh.
page 8, but,
Maybe the copies didn't include the highlighting possibly?
I think,
Right.
we do have the new language. It seems fine.
So on line 9, just out of curiosity, do you have the words local, state, or struck through?
Yeah.
But
The strike throughs are there.
Gotcha.
Well, that's
Hopefully that put that up. Do that, that's yellow. Correction. In theory, it works. Right. All right, so I'll keep that in mind when I point out the other changes. So those are the last two changes in the definitional piece of it. The next section, section 3, page 9, is the petition for guardianship. And that's some instances in which there are no changes there, but you may recall that it's sort of the expedited process that allows for notice and other requirements that are generally generally are required, but there are certain situations in which notice is not required, such as when the identity of the parent is unknown or their location is unknown, and this adds the custodial parent detained as the result of an adverse immigration action is to one of those situations in which you can expedite the process. You don't have to provide notice. You don't have to provide, the identity of the parent if it's unknown, or you have to provide the location if the parent is unknown. And this adds a third situation, which is an adverse immigration action, when you can expedite the process and not have to provide notice requirements that are ordinarily required in guardianship proceedings. So the hearing is in the next section, no changes there. But then lastly, so this, as I mentioned, this consensual standby guardianship is are documents that are drawn up before it. So they're not, you don't wait until adverse immigration action happens. I mean, you could in theory, but I think the ideal situation is that these agreements are drawn up before, and so that everyone's already signed off and consented to them. And that's what it means by consensual. The parents are aware of the consequences and the fact that the guardianship doesn't kick in unless the adverse immigration action happens. So page 15, lines 9 through 11. This is just striking some redundant language. The court, you recall the judiciary and Judge Zone asked about this, and again, legal aid and all the parties agreed that this language was already embedded within what the guardianship agreement had to contain in it. So there was no need to, it was actually just confusing to say it again. So that's lines through 11 is struck. There's another clarification at the bottom of page 13. This is this is what has to be in the agreement that the proposed guardian and the custodial parents sign. All right, you have the custodial parents and whoever the proposed guardian is going to be has to reach this agreement. They both sign it, and the documentation is in place. And this lists what has to be in this agreement that the parents and the guardian have to agree to. And line 20 is really just a clarification that sort of implies that the parties intend to create as if it were happening in the future. It's not. It's current. The parties are creating a standby guardianship. So in that sense, it is in existence at present, even though it doesn't kick in until if and until the adverse immigration action happens. So that's the agreement that has to be filed along with the petition for the guardianship. Then we have the procedure that follows the filing of the petition, and the court has to analyze these different criteria that are laid out, and then it has to reach a decision about whether or not to grant the petition. That's over on page 15, starts on line 12, subsection F. So if the court grants the petition, in other words, if it finds that the criteria have been met for establishing a standby guardianship, if that's the case, then the way it's written now, you'll see that there was a very accelerated time period required that the court had to issue the order within 45 days after the petition was filed. And again, the testimony from Judge Zone was that there might be particular extenuating circumstances where maybe they could meet that 45-day time limit. And I think everyone agreed that a proviso would be added here that yes, generally speaking, on line 14, the 45-day requirement applies, but the court does have the option to extend that time period if they make a finding that good cause has been shown. So that's the idea of language. No changes to the order itself until you get to page 18.
Eric, quick
Yes,
question, line 12, page 14, the phrase relaxed rules of evidence in probate proceedings,
yes.
is that typical language?
Yes, yep, that's what the rule is actually refers to that. Yeah, okay, and it's this notion that is sometimes the case in the law when the legislature, or in the case of court rules, the court, subject to the legislator's approval through the judicial rules process. But there are times when a policy decision is made that strict adherence to the rules of evidence is not going to be required, and they use that term, and that generally means is that evidence commonly relied upon by people in the conduct of their affairs is permitted.
Thank you.
Yep. So the order itself, again, if the court finds by clear and convincing evidence that the criteria for the standby guardianship are met, then it issues the order. And there was some language over on page 18 that was a little bit, I think, confusing when the committee first looked at it, which is that what did it mean that the guardian was going to be required? In other words, the petition's already been granted. What happens afterward? And there was a requirement that the guardian provide notice of all changes to the custodial parent at the parent's last known email address and the parent's attorney at their last known address. And there was, I think, some discussion in the committee about what did that mean? What sort of requirement was that putting on the guardian? And was that clear enough? So I think the parties that who are interested in this issue, all the interested parties took a look at that language and decided that it really wasn't adding anything. You could really just say status reports. So as long as the guardian provides status reports to the parent, then that would satisfy the idea that the parents are kept up to date, basically, on what's going on on a reasonable basis. And that there's also, you may recall, that this agreement, remember, because there's an agreement that also is part of this between the custodial parents and the guardian, and that would also include in it, as the standard form generally does, provisions about how the guardians keep the custodial parents up to speed on developments of the case. So that would be sufficient to cover that notice goal. So that's the change there. Now we're on page 19, a similar one to the one we just talked about court noticing whether or not certain timelines could be met, or whether or not there should be situations allowed for when a timeline could be met. And this was the case having to do with the provision being added here applies to the idea that in many of these situations, or at least some of them, the custodial parents may no longer be in the country. So if they are not in the country anymore, their ability to comply with the filing and formatting and signing requirements that are generally required in the probate division might not always be feasible. So the idea was, well, if they're unable to do that, the way the language had been written was that the court shall accept filings that don't meet these formatting requirements. I think Chair Zone mentioned, well, those formatting requirements are there for a reason, but maybe another way to get at this issue would be to allow for the court to waive those filing and notice, all these formal procedural requirements, allow the court to waive those in a situation where where the parents say are unable to comply because they're not in the United States anymore, or they've been removed, and so they're perhaps in detention somewhere and can't satisfy those requirements. So that's the way the language is written now, tries to allow for the same option that the court may, for good cause shown, accept filings that don't meet these formatting and signing requirements. So good cause could be, for example, that the parent is detained or no longer in the United States. That's the idea. And I think that's the last proposed change to the bill as it was introduced.
Looks good altogether, you know?
Yeah, especially the second part. Committee, any thoughts, questions? Well, in that case, I would entertain a motion to vote out H98.
So,
Ten votes. Any further discussion? Okay. I take a couple, please.
Senator Norris,
Yes.
Senator Biegelski,
yes.
Senator Baru,
Yes.
Senator Meadows, yes. Senator Hashim,
Yes.
500.
All right. So I can report this one out. You're picking up this one today.
That's how the changes.
That's 9. No, that one is,
What we're gonna get a walkthrough from Ledge Council, House.
I think we did that
We did
yesterday.
yesterday.
We did that yesterday, and what was their option?
It was mostly just technical. things.
Seems like it.
I just, yeah, that's fine. I just said something bad.
So in other words,
You said it to me already.
now that we can do that one, too, yeah.
Yes, yeah, that's, yeah.
Yeah.
So,
Senator Bruce. I just sent them over to Ben. I haven't received his technical update changes. That was the point of my question. If we're gonna do that today or not. And if he sends that to me, yes, we can do that today at 1.
Okay.
I gotta send him an email.
I know what you're saying. Okay.
So as far as this one goes, it's got to go through the proofers. Which I can ask them to expedite that if you want to report it sooner, but totally up to you.
Yeah.
Then,
Ideally, I'd like to report it on Tuesday. So,
okay, perfect.
no rush with that.
So if they could finish it up by tomorrow to bring it up to.
So would you rather I hold on to this copy and not bring this up?
Correct.
Okay.
Correct. Yeah. And that way there, we'll get a fresh, edited proof copy, bring it up tomorrow. It'll be on notice Friday and then it'll be up for action on Tuesday, I think.
So you can see, Ben, you can tell my son an email there.
Yeah, and wrote this desk on.
Yeah, you say you would, but, it's on notice on Friday?
It would be if we follow that,
Okay.
timeline, if that works.
I missed the, first things.
Yeah. Yeah, that way I'll tell the proofing staff that, if they get it by noon tomorrow or something, I don't give them time to do all that. That works for.
Yeah, for sure.
Actually, I got it. Michelle sent it.
Oh, you do it?
I gotta go print it out. We're good.
Give this another one.
I think that's a wrap for today. I don't know if there's anything else we can